हाँ जी सर. Sir, it's working. सर अभी सर 1 मिनट में चेक करो. अभी खोला है मैंने सिस्टम ना, अभी खोला है. सर कोई काम और भी आ गया था सर, वो कर रहे थे थोड़ा. हाँ हाँ सर, 1 मिनट सर, 1 मिनट दे दो, बस 1 मिनट दे दो ना. कर रहा हूँ, सब कुछ कर रहा हूँ सर. यूट्यूब लिंक भी भेज दिया आपको. कौन सी?
Hello, Nilesh.
Hello, how are you?
Fine, fine. This is AK Mishra from Bombay.
Okay. Morning, how are you?
Fine, fine. Good, good program. But 12:30, no? Another 10 minutes.
Yes, yes, yes.
What is the maximum number of participants here?
No, where you want to ask? It can
No,
be a
because
number of.
number of participants, because before joining, no, I do not want to disconnect. I want to continue. Once you disconnect, it is difficult.
Am I audible to everyone?
Yes, sir.
Okay, okay. Thank
Yes,
you.
sir.
Yes.
You are very well. Okay, okay, sir.
And in their claims, they have to mention the name of one of the AR whom they are choosing. So out of suppose such 100 claims, if 60 are choosing one person, 30 are choosing second person, only 10 are choosing third person, then the person who got the highest number of choices will be selected here on behalf of the home buyers of all the 100 buyers. And then in that case, IRP, on the basis of that choice made by the home buyers, we move an application adjudicating authority.
It is not, your voice is not
This is not audible.
Within 2 days of verification of claims, there are 20 timelines given under section of the resolution 40B.
We can't hear you.
He has to keep that application within a period of 2 days after verification of claims. So he has got very, very little time. He has to be very, very expeditious, very fast. He does not need to wait for the time period to lapse for filing of the claims. As soon as he starts getting the claims, he has to make a folder of each. Class, there is a meeting of these teams. AR is not appointed. This is a very big question which is being raised.
Hello. Sir, your voice is not audible. Hello. Hello.
Hello.
So we are unable to hear anything.
We have yet not started. Let the Chandok sir join in. We'll start then.
Okay, sir.
Sir, can you hear us? Chandok sir, can you hear us?
Yes, I can hear you.
Sir, but we cannot see your video, sir.
Just give me 2-3 minutes.
Okay, sir. Thank you so much, sir.
Thank you. Review of revision and appealable orders. Appealable orders.
जाओ तक नहीं तो खाए ना
Hello, everybody. I hope I'm audible to everyone.
Good afternoon, sir.
Wonderful afternoon.
Good afternoon, sir.
Good afternoon,
Good afternoon,
Shekhar.
sir.
Good afternoon, Ravina. Good afternoon to everybody.
sir. Good afternoon, sir.
Doing very well.
Good afternoon, sir.
Good afternoon, sir.
Good afternoon, sir.
Sir, you are not properly visible. You switch off the background light.
Good afternoon, Chandok sir.
Good afternoon. Good afternoon. Can you see me now?
Yes, sir. Yes, sir.
Okay. Good afternoon. Good afternoon, Chawla sir. We have a webinar today of relating to code of civil procedure, which I think each one of you know better than each one of you, especially for me. And the webinar is with respect to subtopics called appeals, review, revisions, and then we go to what is appealable orders. Well, as I said, code of civil procedure is the Bible for all civil proceedings. There is no other procedure that is heard of or seen in individual jurisprudence relevant for our purpose. This has been amended many times, but the last amendment is 2018, when we brought it with respect to the Commercial Courts Act. We can divide this Code of Civil Procedure into two divisions.
Sorry, sir. Please bit little.
1 to 158, and the other relates to Order 1, Rule 51. We are only concerned with some of the sections since we do not have any federal courts now. Those provisions stand now deleted from the Code of Civil Procedure. Section 96 is the enabling power for a litigant or for a party to a list to ask for an appeal. That's where the right gets established. Section 96 says you can file an appeal to the appellate court against any decree. But if you now see corresponding in the second division, where Order 41 comes in, there the word has been amended to use the word judgment. So earlier, filing of the decree was an essential element to prefer an appeal against a decree. But after the substitution of the word judgment, you can file a prefer an appeal against the judgment itself. And another interesting aspect, I must bring it to the notice of everybody. In Delhi, there is a Punjab Amendment Act which applies to Delhi and which says you don't need a certified copy. An authenticated copy to lawyers by a lawyer on record would be sufficient. At least some preference is given to lawyers somewhere in the statute now. After 96 brings in the question with relating to Section 112. 112 says that nothing in this code shall affect the powers of the High Court of Superintendents under the Letter Patents Act. But please consider the letter patents was responsible for constituting Bombay, Calcutta, and Madras. Delhi is constituted by an act of the Parliament of 1966. So the letter patent is made applicable by the Punjab High Court, made applicable to Delhi. Consequently, 112 does not bar the question in relation to the exercise of jurisdiction by the letter patent under the Letter Patent Act. However, a word of caution is necessary. An amendment is brought about today in the statute to say that if a suit or a decree has been appealed before the High Court and the honorable single judge has looked at it, in that eventuality, you cannot have a appeal to the division bench of the same High Court, what we call as intra-court appeal. All of you would recall under the Hindu Marriage Act, for example, we used to have an appeal coming from the district judge before the family courts were constituted. Now, after the family courts are constituted, the appeal actually goes to the division bench itself. So there is no question of an appeal going to a division bench after the single judge. But as long as we had Hindu Marriage Act, as long as we did not have Family Courts Act, a single judge judgment of the High Court used to go in a letter-based appeal before the division bench. But a departure was made in the CPC itself to say, once an appeal is heard by the honorable single judge from the original decree, whether it's Hindu Marriage Act or a money decree or anywhere else, or a district judge, the appeal will not go intra-court appeal. Please take note that we are only talking of appeals. The webinar is restricted to the Code of Civil Procedure. I am neither referring to, nor it is relevant for me to refer to, an appeal arising out of statute if it allows you to an appeal to go to the intra-court appeal. For example, under the Delhi High Court Act, Section 5 provides for an appeal which goes to a division bench, which is an intra-court appeal. Now that appeal is governed with respect to Code of Civil Procedure, but still, because of the Delhi High Court Act, a single judge appeal from the original decree goes to the division bench. So therefore, to that extent, there is no conflict whatsoever with respect to the same. Now the question that arises is whether that appeal is the right that is given to me, and supposing an amendment is made in the statute, some statute, where amendment takes away that right. And to give you an example of 2018, the Commercial Courts Act, the question arose and is still, of course, a subject matter of dispute or a conflict of opinion between Delhi High Court itself, that whether a right of appeal which accrued to me when a suit was instituted prior to 2018 or 15 when the Commercial Courts Act was enacted, whether that right gets exhausted, whether the right gets impeached, that right gets impeached after coming into force. There is a conflict of opinion today with respect to the two benches. However, the first principle is correct, that if a right has accrued to me on the date of when I filed any proceedings, that right would continue to be accrued to me or to a litigant, notwithstanding subsequent, unless the statute specifically takes away that right. Take, for example, Delhi High Court Act. Take, for example, under Delhi High Court, we used to have a special second appeal under the rent control coming from the tribunal. Now, this has not been taken away, though the amendment has taken pay to say that the tribunal will be the last court of appeal with respect to rent control proceedings. However, I'm not referring to the chapter 25B, where you come to a revision court before the High Court. I'm referring to appeals alone. Consequently, the question that arises for us all lawyers is, when does that right get accrued to us? And the law is absolutely clear, right from Vodafone judgment of the Supreme Court, saying a right accrues for appeal on the date when the proceedings are instituted. Unless subsequently that right is taken away, that right would still accrue to us. As I said, there's a conflict of opinion. I'm not going into those questions at this moment because we are only concerned with CPC. Now, once you get that decree, the judgment goes in appeal before the appellate court. The appellate court then looks at what we call as RFA, regular first appeal, in terms of section 96. Here, both questions of fact and law are open to the first appeal court. It is not necessary for us to look at it that there is anything substantial in it or not. It is like a continuation of the original proceedings, and the first appellate court is entitled to look at both at facts and law and correct the judgment insofar as it is in error either in law or in fact. But then comes another portion of the law, which is section 100 of the Code of Civil Procedure, which says a second appeal would lie. In other words, to give you an example, a sub-judge decides a case, it goes to the appeal court before the honorable district judge, and you come in section 100 in a second appeal before the High Court. But that appeal is not open to every question of fact or law. It is only open to a substantial question of law. And the Supreme Court had the occasion to look at it to say, even where the learned trial judge or the first appellate court has gone wrong on fundamental facts pleaded in the pleadings of the parties, which are again the Bible to any civil proceedings or any civil proceeding in civil court, then also a substantial question will arise under Section 100 of the Code of Civil Procedure. Let me also tell you all, my friends, that the law requires that your appeal, unlike the first appeal from the decree, which is under Section 96, tells us that in our appeal, the substantial questions of law, which according to the appellant arise in that second appeal, and if we don't plead that, the appeal would be defective and the court would be entitled to either reject it or give you a liberty, or get a litigant a liberty, or the appellant a liberty to amend the appeal. But that's not all. An appellant may raise those questions of law, yet the honorable single judge before whom the regular second appeal will come before the High Court will have to then look at the facts of the case, look at the two judgments passed by the first appellate court and the trial court, and then come to the conclusion whether it's a case where actually substantial questions of law which requires consideration by the High Court arise actually or not. Normally speaking, a concurrent finding of fact given by the two courts below normally is not interfered with. However, the question is, if both courts go wrong, either on facts and law or its applicability, the High Court will be entitled to frame that substantial question of law in that appeal and decide the same in accordance with law. The question arose interestingly that neither the honorable judge nor the appellant had framed any substantial questions of law in their appeal or in the order. But the case was looked at and decided. Way back in 2005, the Supreme Court had an occasion to look at it in Draupadi Raju's case and said, it's a duty cast on the court. And if the court has not abdicated its duty, then any judgment pronounced by the High Court in terms of Section 100 is not proper and is illegal and was set aside. Therefore, care has to be taken both by the appellant and the court in the regular second appeal with respect to whether substantial questions of law are framed, which must be then addressed, because unlike RFA, which is open to both fact and law, this is not open to that. And even if the appellant and the court was to write in the beginning, even the absence of the respondent, was to frame the questions of law, the respondent is entitled in law to come back to the court to say these questions do not arise. Therefore, the framing of substantial questions of law has become important in terms of Section 100 of the Code of Civil Procedure. Therefore, we have to take care in what we are doing in relation to that, so that we don't mistake in doing these things. They say law procedure is handmaid of justice, but if you'll see two judgments, one by Justice Dalveer Bhandari when his lordship was judge of the Supreme Court of India, and thereafter an honorable, both judges in fact went from Delhi High Court to the Supreme Court, Justice Dalveer Bhandari as well as Justice Vikramjit Sen. Both say, notwithstanding that the Code of Civil Procedure is procedural, yet the mandate of the code cannot be made obsolete and needs to be looked at both by the people who are putting their papers, filing their suits, in this case the appeal, as well as the court which is hearing the matter. Consequently, after the judgment of Raju's case, I said in 2005, the question is framing of substantial question of law has become extremely important. Therefore, we have to assist the court while an RSA is coming up, that the court must apply its mind, and while admitting the appeal or otherwise frame those questions for the consideration of the court at the final hearing of the matter. This does not, of course, preclude the court if at the time of filing hearing, it comes to the conclusion that another substantial question of law has arisen, or meanwhile, some law has undergone a change. there has been some substantial change in the facts of the parties. It is possible for the court to look at those facts, frame another question, put the parties to notice, and decide the same. So the starting point is the appeal must have it, the court must frame it, and the last stage is when the court is actually pronouncing the final judgment, can put notice to the parties to notice that these another additional question arise and consequently would not come. Please look at it from distinctively from the Arbitration Act, where we say an arbitral tribunal is the master of both law and facts. And unless there is a fundamental breach or violation of the first principles of Indian policy of law, the court under section 34, which is really the first judicial review of the arbitral award, will have no jurisdiction to look at it with respect to the both law as well as facts. Whereas in a civil court under CPC, you can go right up to the second appeal for getting a substantial question of law determined, and also both the honorable judge of the trial court and the first appellate court are not the final authorities, unlike the Arbitration Act, where the arbitral tribunal becomes the final person to dictate or to pronounce on both facts and law. So distinction will have to be drawn by us in relation to what are we dealing with when we are dealing with civil suit or a civil proceeding governed strictly by Code of Civil Procedure, not even Commercial Courts Act. We'll have to look at it from that point of view. But it's interesting to see that Order 41, Rule 9, which is now the procedural part when the appeal is preferred, says that when an appeal is filed, it will be registered and shall be heard by the court. Now, one part is Order 41, Rule 9. The other part is Section 100, which says you will frame a substantial question of law. So, in my humble view, for consideration of all of you, that Order 41, Rule 9 will have no applicability in view of the provisions made in Section 100 of the Code of Civil Procedure. Therefore, merely because an appeal has been filed, it is registered with the registry, and you have got those numbers, etc., would not mean that there is an admission of your appeal, unlike what we have in a regular first appeal, probably, where your requirement is not to be heard. But experience today shows, even in RFA, I've seen appeals being dismissed now by the court, saying that this case does not require any appellate jurisdiction to look at, and consequently does not like to interfere, even at the first stage. But my humble view would be that we all must assist the court, that the first appeal is an appeal both on facts and law. Consequently, the judgment of the learned trial judge needs to review, first judicial review at the hands of the appellate court. And in terms of the mandate of the Supreme Court has been consistently saying that the first appeal court must come to its own conclusion on every issue that has risen in the suit and then decide whether the trial judge was right or wrong. Consequently, this is the position with respect to one and the other one. Section 100 capital A was added in 2002 in the Code of Civil Procedure, is the next part of the subject, where it says no further appeal to the division bench if any appeal has been heard by the single judge of the Honorable High Court. Therefore, irrespective of the proceedings, let's test it today, that supposing an appeal was to come before the single judge under any statutory provision, unless that statute provides an appeal to the division bench, which I don't think there is any provision as of today, then the moment the first appeal is decided by the learned single judge, in terms of Section 100 capital A, an appeal does not lie to the division bench. As I said, prior to coming into force of the Family Courts Act, we used to file an appeal before the single judge coming from the district judge under the Hindu Marriage Act, for example. Then we used to go to a letter patent appeal. But this Section 100 capital A today says, notwithstanding anything contained in letter patent or in any other law, including the letter patent of the High Court, which also includes Bombay, Calcutta, and Madras, a second appeal to the High Court division bench would not lie. Consequently, that's the change that brings in with respect to the first part. Let us go back to the procedural part of the appeal. Once the first appeal is filed by any appellant, it goes and gets covered by Order 41, Rule 22. I've already said in terms of the Punjab amendment which applies to Delhi, we don't need any certified copy now. We only need a authenticated copy by the lawyer. And keeping in view that we have progressed a lot so far as Delhi is concerned, we have all judgments now available on our website. The said judgment, once downloaded, authenticated by the lawyer, would be sufficient to meet the requirements of Order 41 to 1 CPC. The question would arise, therefore, that once an appeal is preferred, but supposing the suit is in my favor, I have succeeded in the suit, but on two substantial issues in the suit, the judgment has gone against me. So the final judgment is in my favor. So the law is that notwithstanding the fact that on two issues or on few observations or findings given by the learned trial judge, the issues have gone against me. But if the judgment has become final, judgment has come in my favor, then I can't prefer an appeal. The other side must have preferred an appeal. But what happens to the findings that have come against the respondent in this said appeal? So two questions arise. Reference can be straightaway made to Order 41, Rule 22, where it provides that if the respondent or the defendant in that case was to prefer an appeal, then you get a right to agitate before the appellate court and request the court and insist it to say that these findings given against the respondent in that appeal, say the plaintiff who has succeeded, but now is a respondent in the appeal, that finding on a particular issue or a finding of fact or finding on terms of law is erroneous and can agitate the same. In my view, there is a semicolon if you see Order 41, Rule 22 after the amendment. And it says it can assist, that means the respondent can insist and assist the court to say that such finding is wrong without there being a need to file a cross objection. However, there's a semicolon thereafter, but an explanation has been added, which explanation says we must file a cross appeal or cross objections to that appeal, which a right accrues to the respondent within 30 days of filing of the appeal by the other side who's aggrieved by the judgment or the final decision going against him. Consequently, you get a right to file an appeal, but you can't file an appeal merely because some findings are against you. Consequently, that appeal must await if the respondent was to prefer an appeal. If the respondent or the defendant in the suit prefers that appeal, then you get another right. Not connected with Section 96. It is connected with the law, as it says, a right gets accrued the moment the defendant who did not succeed or against whom the plaintiff has succeeded, for example, will get a right to go in and file a cross objection in terms of Order 22, Order 41, Rule 22. Many may ask a question that if the statute has put a semicolon, then why can't it be done without it? My personal view would be yes, it can be done, but the explanation is causing that confusion. Explanation can't expand the meaning of the main statute, but however, it has been interpreted today by two high courts to say that in such an eventuality, if the respondent in the appeal desires to get those two findings or two issues reversed against him, so that the final judgment he succeeds, he is entitled to, he must file a cross objection. Now that's a dispute. We'll see as and when it gets into the decision by the Supreme Court. Another 2 points I wish to make very bluntly. A, our recent experiences show that either whether it's in the plaint or in the written statement or even the appeal, we start writing everything possible on the earth with respect to the case, including saying Shamnath versus Ramnath in AIR 220 or AIR 219 or 18. The Supreme Court or the High Court in particular case said this. The word used in Order 41 are, you will only give a nomenclature and grounds on which you are assailing the judgment of the learned trial judge. Consequently, say grounds. Nomenclature is meant to be only give a story on brief facts in the case, or what fact the learned trial judge or the learned judge against whom you are going in appeal has missed. It is possible, but request is that we must all consider this question, that we may not start quoting our judgments and the entire case what evidence has been left, etc. in the appeal. It only says grounds of appeal are required, and therefore your grounds must be more specific. Because unless you take that ground, it is possible at the hearing, the learned appeal court may say, you've not raised this issue, not raised this ground. Therefore, the stress is not on narrative, please. The stress is on grounds. And once you raise those specific grounds against the judgment, then only it will come. And though the Delhi High Court had an occasion where I assisted the court to say that the written statement, for example, in that case, had no denial, really speaking, except saying in NDMC versus so-and-so, in MCD versus so-and-so, such and such thing was held. The court agreed with me, saying that such pleadings are no pleadings in law. It will equally apply to the appeal if it was to have that. But if we were to reject all this, then probably every appeal or suit coming to the court will have to be rejected. But I think time has come with the new COVID-19 going in, with the new dimensions that we are looking at, the entire world changing to us. We are now looking at virtual hearings in our courts. If we are more specific, we abide by the spirit and letter and spirit of this law, I am sure our hearing will be more useful and beneficial to the litigant and to make up the judicial system better robust for ourselves. Look at an irony of the situation. When the government thought lawyers must have a refresher course every 5 years or 10 years, I don't remember what was the period they were discussing, entire legal community stood up and said, what is this? Once a lawyer I have got registered with Bar Council, this is sufficient for us. We don't need all these refresher courses, which are there in every other part of the world. But this pandemic has actually brought enthusiasm within us. And we are holding these webinars from every day. And I find sometimes 4 or 5 a day, where we are, what are we doing? We are talking to each other and educating ourselves to see how can we better officers of the court in assisting both the litigant and the court in pronouncing a better law. Therefore, I think learning is a process which should not defeat whether we are within COVID-19 or even if the lockdown period gets over and we go back to our normal functioning. This brings me to section 104. And section 104 deals with a second set of orders. I'll come to review and revision in the end, because that's a little shorter subject. Since I've dealt with the appeals against the first part, these are orders which are relatable to order section 104, and then read with section order 43 of the Code of Civil Procedure. If you have I'm sure each one of you have seen order 43. Order 43 tells us, enumerates appeals from appellate. Therefore, all those appellate orders, appeals from orders are initiated with respect to what kind of appeals can be referred to it. Order 43 is referred with respect to an order. Now, the question that arises, what kinds of orders are appealable? And to cut short this controversy, apart from what is already enumerated in the Code of Civil Procedure, I think the first part is after Khemji's judgment of the Supreme Court, the full bench judgment of Delhi High Court and University of Delhi, where they said section 10 does not give a right of appeal, is no longer a good law. And consequently, the question today is, after Khemji's judgment, any interlocutory order, I'm not referring again to my friends to the Commercial Courts Act, which bars that position specifically or takes away that right of revision or an appeal, because it restricts itself to section 13 to file an appeal in the commercial court. But we are talking about CPC. Now, in a CPC against any interlocutory order coming from a district court, you have two remedies. One is a revision, and many times we have used that revision with a reference to Article 227 if there was an error of jurisdiction. And if there's an error of jurisdiction, then we have straight away gone to section 115. And where section 115 is extremely restrictive, we've gone to Article 227. But let me talk of the orders now with respect to which appeals from the orders which come into play. Now, the orders will only be in respect of, again, appeals from the orders, which is the heading of that. It gives us all these details, but what happens to it? The order is passed by the learned single judge. That order affects our rights, but we can't prefer an appeal against that order. Now the question is Order 43 exhaustive? The answer was given by none else but our Chief Justice of India, Justice Thakur, when his Lordship was in Delhi High Court, where his Lordship said Order 43, after Khimji's judgment, will have to be read in the context of their judgment. The judgment lays down that if an order affects the rights of the parties, if the order in any way is prejudicial to a litigant or to a party to the list, then that order would become appealable. Therefore, the Lordships of the view that notwithstanding the words of the statute, 104 read with Order 43, if the order in terms of the law laid down by the Supreme Court in KMG affects the rights of the parties, then that order will be appealable. And let me give you a very small example. If you all see Order 6, Rule 17, which you probably use almost every day, amendment of the pleadings. It now provides that if the trial has begun, because there's a controversy when trial begins, but I'm not going into it. Mr. Anil Hari has already done with that part. I am only saying that the statute provides today that if the trial has begun, then amendment can't be allowed. But if during trial, facts come to our notice, during cross-examination, many facts are divulged by the witnesses, then first principle of law is I cannot look at any fact unless I pleaded it. So if I plead that fact, and the court was to take a technical view that since the trial has begun, I will not allow it, then the whole purpose is frustrated. Therefore, the Supreme Court had an occasion to look at it, and it said, if it will depend on facts of the case, don't go look at technicalities of law to impinge the justice. Therefore, ultimately, the word is justice wherever we want to look at it. And consequently, Order 6, Rule 17, notwithstanding providing that you can't do it if the trial has begun. The view is that if the facts and circumstances of the case require, and that fundamental principle of law remains the same, that I can't urge what I have not pleaded, then pleadings will have to be amended. And once pleadings are amended, your grounds of appeal may get amended. It is many times that we have seen, even in appeals that we have referred, that we have filed an amendment application, which the court has then considered and remanded the case back to the party, to the learned trial judge, or to the first appellate court to say, this aspect of the matter requires reconsideration after you decide the amendment. Therefore, appealable orders are restrictive. But in view of Khimji's judgment, if we can bring that order within the four corners of the law laid down by the Supreme Court, that the order is prejudicial or will bring injustice at the end of the day, that order will become appealable within the ambit of 43. But 43, as I said, that is being interpreted in two forms today. One court, one division bench has taken a view that proviso to Section 13 of the Commercial Courts Act, though not relevant for us, only to give you the distinction between it. In fact, enhances the jurisdiction of Order 43, yet one court says it has to be strictly followed. Without going into that question, I can only give you one more example. Under Order 39, Rule 1 and 2, the word used in CPC is a suit, not an application. Normally we see it's an application decided, but actually the words of Order 39, Rule 1 and 2 is, in a suit, the plaintiff is able to make out a case. But we have seen where the injunction sought by a plaintiff may not strictly fall within the four corners of Order 39, Rule 1 and 2. The court has said it is not exhaustive. Consequently, the same principle, in my view, would apply to Order 43. Therefore, all orders that are appealable must stand either incorporated in Order 43 specifically, then there's no difficulty. But if they are not incorporated, then the question would obviously arise, what happens to such orders? And if we stand the test of KMG, that it affects the valuable rights of the parties, then an appeal would still be live. Therefore, an appealable order would be one, really speaking, unless provided in Order 43 or is prejudicial to the interest of the litigant. either side, whether plaintiff or defendant or otherwise. Therefore, an appeal would go to the appropriate court with respect to the same. The question would only comes to now left with me is in relation to a revision and review. Order 47 deals with the review. The review can file even with an appealable order, provided one has not preferred the appeal. And once you file and review, and you're able to prove those grounds that are there, you're able to establish that there's an error apparent on record, or there is something which is so apparently missed by the learned judge, which looks at vitiating the situation. We find there's a distinction in law between recalling an order and review of the order. A recall of the order would be an order without jurisdiction, but a review would be restricted under Order 47. So Order 47 can be only looked at like we have in CPC for a civil court to do it, but a tribunal or for that matter any other jurisdiction, unless the power of review is specifically conferred, CPC would only aid if the power is there. If no power is there, then Order 47 would not come to the aid of the litigant, seek review thereof. As I the other day asked somebody under the IBC, now if the resolution plan in terms of Section 31 has already been passed by the adjudicating authority of the National Company Law Tribunal, then there's no jurisdiction today, keeping in view the COVID-19 situation, to go back to say, oh, sorry, I did not provide a force majeure clause there. Please review your order and add to it. So it's contractual. The Committee of Creditors will have to look at it. That's a different matter. But to my mind, unless a review power is conferred on a statutory authority, you can't take aid of Order 47 to say a review would like. However, these are also restrictive. The restrictions are there is an appealable order, no appeal is filed. There is a sufficient ground for somebody to say. And in Delhi High Court, we must also take care that there's a requirement of the format. A review will have to be filed by a certificate from the lawyer that according to his certification, there are sufficient grounds for the learned trial judge or learned appellate judge or whosoever review you are seeking review of the order. Though the courts are ignoring this, but I'm looking at is post-COVID-19, everything will probably come to our aid or will come against us. So we better be careful when we are looking at it to say, our own experience shows that many times one node agrees just to omit that part. Technicality should not come in the way of the court. However, if a provision is made in the statute, then the first principle laid down by Privy Council was, if a particular thing has to be done in a particular way, it has to be done that way, otherwise no other way. So if that principle has to apply, then I'm sure we need to look at these technicalities. Come back to Section 115 of the Code of Civil Procedure, which brings me to the question in relation to revisions. Revisions are preferred against where a case is decided. Again, order is prejudicial, but the jurisdiction is extremely limited. The learned advisory court, you will see even under the Rent Control Act, after the Section 25A onwards was introduced, Section 14, capital A, capital B, capital C, capital D came in. We started looking at it revisions only. An appeal doesn't lie to the tribunal, and a revision lies to the High Court. Now there's one revision provided under the statute, which gives his own yardstick. When will the court interfere in a advisory jurisdiction under the Rent Control Act? But unlike that, the CPC 115 is extremely restrictive. And that is why, by way of abundant precaution, most of us write, in case it is contended and held that Section 115 does not apply, then please apply the jurisdiction vested in constitutional jurisdiction under Article 227 of the Constitution and do it. In fact, after the Rent Control Amendment, we have now started invoking 227 even in respect to second appeals coming from the Rent Control Tribunal. But that's a different question. I'm only restricting myself to a revision under the Code of Civil Procedure is extremely limited, and the court will have to only look at an error of jurisdiction or its decision that affects the rights of the parties. But a revision does not lie from, for example, from a single judge decision. We'll have to go and appeal. You'll find a very recent decision in March 2020, where the division bench presided over by the Honorable Chief Justice, from an order coming from a joint registrar, went to the went in appeal before the learned single judge, then went to the division bench against the order of learned single judge on the division side. And the court has now interpreted with respect to when would an appeal preferred in respect to even in commercial matters. But that's apart. Is revision is a very restrictive right given to the litigant. Only if you fall within the parameters of 115 can you invoke it. Therefore, by way of own precaution, we take aid of Article 237. I am sure I have dealt with the four subjects in little time that I had. I may have even exceeded the time that I've been given. I must answer my friends' questions that may be asked to me so that I should not deprive the questions to be answered at my end. Thank you.
So the audience can raise their questions.
Yes.
So, sir, this is by Amit.
Hi. Can I ask the question, please?
Yes, please.
Please do.
Sir, my question is, supposing in a second appeal,
Yes.
both the courts gave concurrent finding of facts,
Yes.
which were wrong.
Yes.
Can it be treated as a substantial question of law in second appeal?
Yes. I think I raised that issue myself, that this occasion arose before none else but a judge coming from Delhi High Court, Justice Arun Kumar, when Lordship was a judge in the Honorable Supreme Court, that he was able to show, and I want to give an example of to everybody on this, maybe a little interesting, nothing to do with your question, but
Yes.
something to bring home that argument.
Right, sir.
A suit was filed claiming that I am the illegitimate child of my father after the death of the father. But even as an illegitimate child, because marriage was performed with my mother, was void in terms of Section 16,
Right.
I'm entitled to the estate of my father.
Right, sir.
The trial court decides the issue. The first appellate court decides the issue. Matter comes to the Supreme Court. And what was interesting to see was that if what was pleaded in the plaint was to be looked at, then the mother would be only 12 years old on the date when the marriage could have taken place. In law, it would have been void. But see,
Yes.
nothing to do with Section 16 at all.
Yes.
So the Supreme Court comments on it. So to answer your question, if both the learned trial judge and the appellate court have not seen glaring facts, then in terms of the law laid down by the Supreme Court, even otherwise, the substantial question of law would be, what is that omission and what is the effect in that? Therefore, even that can be interfered under Section 11. Under Section 100, there is no bar.
Thank you, sir.
Hello.
Yes.
Sir, I had the question to hear you on that Commercial Court Acts also. Don't you think
Yes.
the Commercial Court Act as well as the CPC have conflicting provisions in it?
No, there are no conflicting. The Commercial Courts Act has amended the Code of Civil Procedure. So it is the amended CPC that applies to Commercial Courts Act, unlike its normal civil suit. So supposing I was to file a suit for money, which has nothing to do with the commercial court, or it is a transaction which is between two brothers, which may not be really Commercial Courts Act. Therefore, CPC as unamended would apply. It may not, unless you bring your dispute within the section of 21C of the Commercial Courts Act. The CPC as it exists applies. The amendment only applies to Commercial Courts Act. So certain rights, as I told you, take for example, under the Commercial Court Act interlocutory order, you can't file a revision at all. You even can't file a question. To me, it may be unconstitutional, but it says even if there's a jurisdictional question that you've raised in Commercial Courts Act, you can't file an interlocutory motion before the High Court or before the division bench. Now that may be a different question whether it's valid or it's invalid. But as of today, a right given to us under 115 is taken away by the Commercial Courts Act. Now, if you remember when we enacted section in a Delhi Rent Control Act, for example, where we said tenants paying more than 3,500 would not be covered by the Rent Control Act. The Supreme Court said, upholding that amendment, to say a right gets to you, that right can be vested, but right can always be taken away by the statute. So by a subsequent amendment, the Commercial Courts Act takes away that right from a party in a commercial court. So there's no inconsistency between the two. The procedure as amended by Commercial Courts Act would only apply to commercial disputes and would not apply to civil procedure. However, CPC as it exists prior to 2018 amendment would still apply to civil courts.
Thank you, sir. But the point is the same is that after 2002 amendment in CPC and now with the enacting of the Commercial Court Act, their revisional powers have also gone.
That's right. Therefore, be a subject matter of your challenge in the Supreme Court or in the High Court to say this amendment is wrong. But that can't be said as inconsistency. When you have a commercial
Got it,
dispute,
sir.
the purpose is this today, brother, that in a commercial dispute, timelines are framed. So we have seen many times the revision coming or 227 invoke when we found the stays are granted and the suits linger on. So the statute makes compulsory today and prohibits from doing so. Consequently, that's the position that is emerges today. Unless somebody challenges and the court holds, of course, ultra vires, that's a different question altogether.
Thank you very much, sir. So nice of you. Thank you.
Sir, can I put a question?
Yes, sir,
Excuse me, can I put a question?
Yes, yes, Amit.
Please do.
Sir, kindly cite a judgment. Hello?
Which judgment?
Sir, kindly cite a judgment which you referred that orders other than Order 43, they are appealable. If it
It's a judgment by Justice Thakur, sitting at a division bench in Delhi High Court in 2008 or 9. Just check up that. You want a citation? Send me a mail. I'll give you the judgment.
Thank you, sir. Thank you.
It's a judgment by Justice Thakur. I'm sure on that.
Sir, there is a question, sir.
Good afternoon, sir.
Good afternoon.
I am Amit.
Yes, yes Amit.
Good afternoon, sir. Amit Jagga this side. My question is, sir, if an appeal is dismissed except on the ground which are appealable, if an appeal is dismissed under Rule 11, which is a ground except the ground which is appealable under Order 43, Clause P and U, is the second appeal only remedy in that case?
No, brother,
if it is dismissed under Rule 11.
The question will be twofold. One would be the court holds that interlocutory order appeal is not maintainable. If that's the situation with respect to the same, then when you're challenging the decree, if the judgment goes against you, you're still entitled to come back and challenge it. And let me give you a concrete example of it. If you file an application before an arbitral tribunal, for example, to rule on jurisdiction, and now there's a provision of Rule 6A now, which says it's not necessary that every interlocutory order you must appeal. You can reserve your right and challenge it when you're challenging the final appeal. Therefore, if the court was to reject your appeal on 11, you are still entitled to, if the judgment goes against you, to challenge it in final judgment.
Oh, thank you, sir.
Thank you so much.
Sir, there is a question, sir.
Yes.
Sir, can you throw a light on the aspect of dismissal of application under Order 37, Rule 7, when the time to leave to defend is not extended and the order is passed and consequently a decree is also passed? So, sir, normally there is a confusion of judgments whether a revision or an appeal should be filed against the same.
If you would recall, I think it's a judgment by Justice Sen when his lordship was in Delhi High Court. He says if the interlocutory order results in, let's test that argument from something else. My leave to defend is dismissed. The judgment will follow. So your earlier view was you could challenge that order also. But that has been set at rest now. It says you can file a first appeal against the judgment because that order merges into the final order of the court when the judgment is passed. Therefore, in 7, result is the same. The final judgment is pronounced. Therefore, when you challenge that final judgment, you will also challenge that interlocutory order, which you are saying in Rule 7.
So by that, we means that we have to file an RFA.
That's right, RFA. You're right, absolutely. Because that order does not subsist. It has merged into the final judgment.
Yes, sir.
But interestingly, let me answer you in a different way. Order 37, Rule 4 says even after the judgment is pronounced, the court is entitled to set aside the execution even. Please see the wording of the order 37 rule 4. So
Yes,
there an
sir.
RFA won't come in. From a Delhi High Court, of course, I'll go to the division bench. But then the question would be, when a trial judge is doing that order 37 rule 4, I'll certainly come in revision before the High Court. So this is a distinction I'm making. In 37(4) applies even post decree, even execution pending. It does not apply in relation to that. So consequently, the extension of time is a different question. You will have to challenge that part.
Thank you so much, sir, for the same.
Thank you.
Hello.
Sir,
Good
is there-
afternoon, sir. Am I audible?
Yes, you are audible. Continue.
Yes. Hello. Sir,
Yes,
how do we
yes,
differ? Yes, sir. How do we
Yes.
differ between filing an appeal between an FAO and a CM main? What are the difference in grounds?
Sorry, say that again. I could hear you, please.
So how do we differ between filing an appeal in an FAO and a CM main against an order of a single judge?
Against a order of?
A single judge. How do we choose between a FAO and a CM main?
No, but from a single judge, you can't file a CM main, brother. CM main can only come from a district court. A honorable single judge of Delhi High Court, you have to file an FAO if it applies. If you come with an order 43, you can do it. You can expand the meaning in terms of KMG. A CM main doesn't apply to honorable single judge. However, you can file a CM main in relation to a order passed by a district judge or a sub judge directly to the High Court under 115 if you can make that, or Article 227 if you are able to make out those 5 grounds which are fundamental again. 1, there is an error of jurisdiction. 2, you are not, principles of natural justice have been done, or something so important which is apparent on the face of a record, the learned judge has ignored it. If the error of jurisdiction, you'll have to bring it. Then only CM main would lie.
Yes, sir. Thank you.
So, sir, since there are no more questions coming up, sir, let me
Thank you so
conclude.
much. Thank you, everybody.
So, thank you,
Thank you,
Chandok sir,
sir.
for such an. Yes, is there any question? Thank you, Chandok sir, for such an
Thank you so
enlightenment.
much. Thank
Thank
you,
you,
everybody.
sir.
Thank you, Robbie. Thank you, everyone. Thank you,
Sir,
all
on
of
the
you, for being here with me. Give me strength and energy back to work. Thank
Sir,
you so
we
much.
appreciate your lecture for throwing light on the subject once again. Accept our small token of thanks from the lecture series on law, and for
Thank you
giving
so
the
much.
wonderful lecture, for sparing your time once again for the group. Thank you so much, sir.
Thank you so much, everybody. Thanks. Have a great day. Thank you to everybody. Thank you.
Thank you, sir.
Bye-bye.
Bye.